Thank you all for joining us today, and welcome to an expert discussion on Grading the States, an Analysis of U.S. Psychiatric Treatment Laws, a new report launched today by the Treatment Advocacy Center. You can find the report on our website, treatmentadvocacycenter.org. We'll also post a link in the chat window. The Treatment Advocacy Center works to eliminate barriers to the timely and effective treatment of severe mental illness. The crux of our work focuses on the promotion of laws, policies, and practices for the delivery of psychiatric care and supporting the development of innovative treatments for and research into the causes of severe persistent psychiatric illnesses, such as schizophrenia and bipolar disorder. Today's report focuses on state laws that provide for involuntary treatment for psychiatric illness. This includes whether an individual who needs involuntary evaluation or treatment can receive it in a timely fashion for a sufficient duration and in a manner that enables and promotes long-term well-being. Whether a person receives timely, appropriate treatment is almost entirely dependent on what state that person is in when the crisis arises. Our national approach to treatment to psychiatric illnesses is effectively 50 different experiments, with no two states taking the same approach. Our patchwork system means many states create needless barriers to treatment with confusing, vague, or outdated laws. The new report finds that despite bright spots, many states do not allow for timely, appropriate treatment during a psychiatric crisis and beyond. The report assigns each state's laws a letter grade and recommends specific statutory changes to improve each state's criteria for inpatient and outpatient treatment. Good laws are so important because outdated and vague laws increase the likelihood that someone in severe mental health crisis will interact with the police and the criminal justice system, can delay treatment, and can increase the severity of illness. We should note that this report specifically examines state laws, not how these laws are implemented. Some states have notable gaps between strong laws on the books and poor implementation and access. But by focusing on the laws, our hope is that this report will serve as a blueprint for policymakers, legislators looking to make critical reforms, and to supply advocates and family members with a tool to guide their activism. The right laws provide the foundation for good systems. Like many of you joining the call today, my story about becoming an advocate for people with severe mental illness begins with my family. As I recently wrote in a Washington Post op-ed, my brother was diagnosed with paranoid schizophrenia in 2007. My family cared for my brother. We also experienced the frustration and the pain of a mental health system that increased suffering by creating unnecessary barriers and the increased likelihood that police would need to get involved in order for my brother to get help. As a young Black man with severe mental illness, my brother's interactions with police were doubly fraught with peril. He lives in Georgia, that's my home state, but in Georgia, Georgia is a state that people have to pose an imminent threat or an immediate risk of death or serious bodily harm to themselves or others before they can be involuntarily hospitalized. At the same time, for police, facing imminent threat can constitute legal justification for deadly force. This is a space that I call untenable, and many of us live in that space. For my family, race makes that space more difficult. For other families, it's poverty. For other families, it's the intersection of substance use disorder. And for even other families, they have the financial means and still find themselves in that space and powerless. These are the stakes for families and our loved ones that we are talking about in this report. For each state, this report represents a bulleted list of how state laws must change. It provides a roadmap to laws that would make my brother safer, your family safer, and your loved ones. And with that, I will introduce our panel members who are going to tackle these topics today. We have Lisa Dailey, JD LLM. She is Director of Advocacy for the Treatment Advocacy Center and co-author of Grading the States, an analysis of U.S. psychiatric treatment laws. She previously litigated human rights and civil rights cases, including pro bono work with refugees. We also have Jeffrey Lieberman, MD, a Lawrence C. Kolb professor and chairman of the Department of Psychiatry at Columbia University College of Physicians and Surgeons, director of New York State Psychiatric Institute, and psychiatrist-in-chief of the Columbia University Medical Center at New York-Presbyterian Hospital. Next, we have Teresa Pasquini, founding member of Behavioral Healthcare Partnership at Contra Coastal Regional Medical Center in Martinez, California, co-founder of Mental Illness Facts, Right to Treatment, a grassroots campaign that focuses on quality standards and equity in care for serious mental illnesses, a longtime advocate for reform and improving the U.S. mental health system. Last, we have Brian Stettin, JD, Policy Director at the Treatment Advocacy Center and co-author of Grading the States, an analysis of U.S. psychiatric treatment laws. He formerly served as Assistant New York State Attorney General, where he was instrumental in conceiving and drafting Kendra's Law, which we all know is landmark legislation that established assisted outpatient treatment in New York. I am your moderator, Sabah Muhammad, and I am very happy to serve on the team with Brian and under Lisa as a advocate and legal counsel for Treatment Advocacy Center. We will get started with Lisa. Please tell us how Grading the States came about, and have we made progress since the last report?
Well, I would say that it came about because among the discussions about what the mission of Treatment Advocacy Center would be was just kind of an identification that the root of change for systemic improvement is really state law, and that's always been a big focus of Treatment Advocacy Center. And one of the things that we've spent a lot of our time and a lot of our focus on is identifying how states are doing in various different topics. And there's no subject that's more significant to the work that we do in trying to reform mental health care than to improve treatment laws, especially involuntary treatment laws. And so we've had different iterations of this report in the past. The first actual report that was of the same title was in 2018, and then this is a 2-year update. So since the time that we first released the report, a number of states have actually improved laws, have changed grades, and have gone up, quite a bit. And I would say that, in general, we've had a good handful of states that have really improved their AOT laws. A lot of them have worked directly with Brian on that. And then we've also had a lot of states that have improved their inpatient treatment laws, and we've worked directly with a lot of them as well.
Okay. That's wonderful. Yes, I've always felt before I became an advocate, finding the policy recommendations, I felt like they reached directly into our home and back into the law. And it was horrifying, but also inspiring to realize, oh, the law is why we can't get help. And I knew that people change law, so that's what I decided to do. So that is very true. It is the root of what's going on in a lot of our homes. For you, Brian, the grade sheets in Grading the States are broken down into 2 sections, inpatient and outpatient, that each allow a state to achieve a total of 100 points. Can you walk us through the different types of commitment standards and the significance of the points they represent?
Sure, Sabah. So I think it's important to note at the outset that the grading we've done here covers a lot more than just the civil commitment standards, right? There are a number of related issues concerning how and to whom those standards are applied, such as who can petition for civil commitment and how long does the order stay in effect. All that is captured in our grading, and folks could take a look at the report to get the full breakdown of those myriad issues that we looked at. But no question, the heart of the matter for us in evaluating states' civil commitment laws is those standards, those criteria. What must be proven in court by clear and convincing evidence to get somebody in mental health crisis who does not recognize their own need for treatment, the help they need, be that hospitalization at a certain point where they're in full-blown crisis, or outpatient commitment, right? Assisted outpatient treatment in a situation where they are not in an active immediate crisis, but are in danger of falling back into one if they don't stay engaged with treatment in the community. And our prism for evaluating that is to basically break down the standards into 3 levels of potential application, from the most basic and universal to the more progressive and credit-worthy standards that some states have. So that first kind of baseline level, which every state has and which nobody would question as a legitimate basis for civil commitment, is the risk of severe physical harm to self or others. That's the basis for civilly committing a person who is violent or suicidal or acting out in some dramatically scary way, such as running into traffic. And, while it's of course essential to get somebody help when they're in that situation, it's not nearly good enough to say we're going to insist on that sort of behavior before we can intervene with involuntary care. So the more progressive approaches, which we have given states credit for, the first line above that baseline level of dangerousness, which happily all but a few states have now adopted with some explicit language in some form, is what we call the grave disability standard. And that simply means that a person's untreated severe mental illness renders them unable to meet their basic survival needs of food, clothing, or shelter. And that allows us to take action when the person, may not be actively threatening anyone, but is clearly neglecting their basic survival needs in a way that raises grave concern. The level above that, the third and most progressive level of a civil commitment standard, which we see in some form in roughly half the states, is what we call the psychiatric deterioration standard. And that's simply the idea of protecting a person from the harm to their brain that results when severe mental illness goes untreated for an extended period. And the thing to prove under that standard is that, 1, the person is at risk for suffering that kind of psychiatric deterioration if their SMI remains untreated. And secondly, that they are unable to recognize that need themselves, making voluntary treatment unlikely. So just a couple more quick points to make about these standards. First of all, just because a state has them, it's not like we're just checking a box and giving them full credit. There's all kinds of flaws that can exist within those standards that make them unusable or unworkable, such as, for example, requiring that the harm in question be imminent, that it be about to happen before you can take any action. That's just one of lots of examples of how these standards, even where they exist, sometimes go wrong. Another point I think I'd like to make real quick is that, sometimes these more progressive standards are thought of as alternatives to finding a person dangerous to themselves or others. We actually don't see them that way. We see all this as being about a person's danger. In the more progressive cases, it's about danger to self, right? Being unable to meet your survival needs or being unable to protect yourself from psychiatric deterioration makes you a danger to yourself. So we kind of reject the idea that we have to go beyond finding someone dangerous. We just want states to have a more progressive and expansive view of what it means to be dangerous.
Thank you. That's excellent. Speaking of the psychiatric deterioration standard, Dr. Lieberman, I wanted to ask you, can you tell us more about the long-term effects on the brain that occur when we delay treatment?
Well, actually, Brian, I hadn't been aware that was the third most progressive threshold or criterion, but I'm delighted to hear it because it represents the fact that the legal process of trying to adjust laws to the advance of scientific knowledge is keeping pace. And I wish that the clinical practices and standards of care were keeping pace as effectively as you've described. So,
which you're trying.
Which we're trying, yeah, but the problem is that everybody's not on the same page. So the way I would sort of frame this is that the efforts of society to try and meet the two dual interests of protecting society and protecting the rights of the individual come into tension. And the criterion reflected in the law as to when you can override somebody's individual right to provide treatment to them, even if they don't see the need and want it, it vacillates, and it's always a step behind. It's behind the state of knowledge and the ability of medicine, healthcare to provide care. And the standard that we're now trying to modify in favor of being able to treat people more effectively, more efficiently, without resorting to them being ready to hurt themselves or others, is a reflection of what went on decades ago decades ago in terms of the quality of treatment, in terms of the incarceration of people in asylums, and the people in terms of the lack of effective services. And the fact that we're holding on to this legacy of the past does a disservice to patients, family members, and society. So I have been in favor of, and the Treatment Advocacy Council has been really in the forefront of arguing for a modification of the standard, meaning it can't just be imminent danger. It should be if a person is so sick that they can't realize what's in their best interests and they are at risk for harm as a result of that, that should be enough. But what Brian is saying is that there may even be another additional factor that should be considered, which I'm in complete agreement about, which is back when I was in training, and I'm going to date myself, in this way, the attitude towards dementia praecox, aka schizophrenia, and related psychotic disorders was doom from the womb, therapeutic pessimism, not do. But research over the past 3 decades has changed that, and we know that the illness is progressive, and that the progressive nature of it is reflected in terms of organic consequences in the brain. So it's a stitch in time saves 9, it's a Humpty Dumpty situation that you can prevent the deterioration if you treat promptly and effectively. But if you let it go on too long, just like with a stroke, just like with a heart attack, the damage can be irreversible. And I would love to see that incorporated into the advocacy for a more modified standard. Because right now the laws are too conservative, and our society is paying the price, and the family members and patients most of all as a result of it.
Yes, absolutely. And with the family members and patients, my next question, well, with the family members paying the price, my next question is for Teresa. You and I are the same in that we discovered that we had to become advocates to get what we needed. When I first started, I was very intimidated by the process. I remember being brushed off by politicians telling me mental health was a family matter. And then I started calling myself crudely the psychopath sister to get their attention because I was just that angry. And you've said you call yourself now a recovering angry mom. How can grading mistakes be used for people finding themselves caregivers and loved ones to loved ones with severe mental illness, when you find yourself in that vulnerable state, to be less angry when you're addressing politicians and the laws and trying to figure the system out?
So thank you so much, Sabah, and it's a pleasure joining everyone today. So yeah, I do call myself a recovering angry mom, but it took me a long time to get that anger wall to come down, and really it was a survival tool for me. I honestly couldn't keep going with the amount of anger. I was forced to my knees, feeling powerless so many times that I couldn't sit in circles and support groups any longer and just talking about how much pain we were in. I was determined to go fix the system. And so my anger actually does wax and wane like any recovery path. There's times when I have anger slips, and that's okay. And families should never apologize for the anger that we have. But, and I unapologetically speak up very proudly about our family experience because I am committed to change. And I think that this report from TAC is a template tool that we can use for change, and in helping to, create pathways of partnerships that where we can all come together and sort of, ease those tensions, learn from each other, understand, what's going on behind my door, when I'm waiting for my son to reach that threshold of, has he suffered enough? Is he psychotic enough? Is he dangerous enough? Is, for me to make that call. And, we have to use reports like this to come together and unite on a path forward. And this is a perfect template to do that. And I've had the privilege of doing that. And so my anger wall did come down eventually because I had the privilege of working with our public health system, which is, I think, one of the best in the nation. And, you know, I did learn what was going on behind their doors. And they learned about what was going on behind mine. And so we worked together to make positive changes in our system. And I think this report can help families and advocates do the same thing across our country.
Excellent. Thank you so much for that answer, and that allowing us to be angry in that space. And no, family members out there, it does change. It morphs into activism or something more hopeful. Now, I would never call myself, I would call myself the hopeful sister, but I am still, you know, advocate angry. Yes, Teresa.
Can I just make one more comment that actually I've shared my family story across the country in several venues. And I did have a national leader tell me once, don't recover too much, because we do need angry moms to drive change. So I held on to that as well. So I don't apologize if I get angry, but I try to keep it in check for my own health as well.
You have to, absolutely. Now we have a question from an attendee, which is, I really want Brian and Lisa to answer this, because it's being new with TAC, I probably ask this question every single day. And it's a two-parter. So the first part is, with so many states and different laws, I'm curious if TAC has an ideal commitment law written that they would endorse for all states to use. And they would like to know, why is there not one federal commitment law instead? So that's, one is about our policies, the other is more about the Constitution, but I will let you all answer that. We can go Brian or Lisa first. Lisa, Brian.
I'm going to leave it to Brian to answer first, because I know he has definite thoughts about this, and then I'll hop in after.
Okay. You're muted, Brian.
Sorry about that, everyone. I've got a dog running around while I'm speaking, but yeah. So the challenge for us in actually trying to impose on all 50 states a model of what it makes a perfect AOT law is that there is room for variation. Doesn't necessarily impact quality. There are different approaches to certain questions that can be taken, that it makes it hard for us to say you're doing it wrong if you make one choice or the other. And a good example of that is, like, it would be the civil commitment standards for outpatient treatment. There are many states that have completely separate criteria for inpatient and outpatient commitment. That is, when you are found to need outpatient commitment, it's not that you are currently in a psychiatric crisis. The criteria are much less about your current condition and more about your history. Do you have a history of cycling in and out of treatment when you're in the community? And are you at risk of becoming dangerous if we don't get you engaged in the community? That's one approach. Another approach that a majority of the states take is to have one set of commitment criteria for inpatient and outpatient, and simply say you are dangerous to yourself or others in one of these various ways, but your danger is not so acute right now that you need to be in a hospital. The community can be a less restrictive alternative placement for you, even though we are finding you currently be dangerous to yourself or others. It's just a different way of looking at it. Either can work, right? That one set of commitment criteria can be effective for AOT as long as you have those most progressive standards that I discussed earlier incorporated, so that you don't have to find that a person is actively violent or suicidal. You can find that a person is at risk of psychiatric deterioration if they don't stay engaged in the community. That's really just as good, and not better or worse, than having separate criteria that don't focus on your current condition. So apologies, it's kind of a long-winded way to say that we don't impose one model law, because there are different approaches that are on equal footing.
Sabah, can I jump in here after Lisa speaks?
Sure. And I guess what I would add to what Brian has said is, basically, there's also just the practical kind of idea of trying to retrofit a completely different law to a state that's just not set up that way. I mean, that's just the system that the state uses for its public mental health system grows up around the law, and to to like just lift that out and put something else in would be just really, really difficult for a system to actually cope with. So that's part of it. And then also I think that, there's a certain amount of respect that's due to the idea that like one state isn't necessarily going to have the same idea about what an appropriate set of criteria is. And it's set up so that, those values are reflected in who people elect to their legislatures, and the legislatures then make those decisions on behalf of people. And by doing that, maybe a state will pass a really innovative law and other states can see how well that's working, and then they can choose to model that kind of thing. But if you impose everything on a federal basis, that's like a floor and not a ceiling. So there definitely, you can get some more innovative opportunities by watching states, try different things. And to a certain extent, I think that actually has sort of been positive, because I do think that some states, if they look at our findings and they find that they're one of only like 3 states that do or do not do something, they might then consider the need to adopt a different model. And it definitely, state practice can definitely evolve, what all of the states do over time.
Yeah, just to amplify one point Lisa made, because I think it's a really great piece of advice for advocates generally. When you're advocating in a state to change the law, you never want to go into a legislature and say, let's throw out what we have, scrap it completely, start from new, let's try and follow this TAC model law. It's always more effective to say, let's work with the language they have, make as little change as necessary to reflect the values we want in the law, and let's figure out how we can tweak the current language to make that work. That's what successful advocacy on the legislative level is all about.
So I think the efforts that Treatment TAC, Brian, Lisa, and others have made, and there's another parallel effort going on, Brian, that you're probably aware of, with the Colorado Mental Health Organization is sponsoring something that Judge Lieberman has been sort of coordinating on draft legislation, alternative legislation. But I think that sort of declares victory before it's realized that an impediment, which is sort of clouded the ability to look clearly at the situation that was born of deinstitutionalization so many years ago and address it through a legislative process, is the fact that there's I don't know if it's a deep-seated or pervasive, but there's a significant ambivalence about the effectiveness of treatment, antipsychotic medication or other forms of treatment. And also there's an ambivalence about the nature of severe mental illness, in particular the psychotic disorders. There is still a very active anti-psychiatry movement. And in our mainstream scientific journals, there's still a debate. There's articles written that are questioning the efficacy of medication. And only in psychiatry would you see this. I mean, in cancer, cardiovascular disease, infectious disease, you would never see anything like this. And there still is a romanticized, euphemistic view of mental illness that some people hold till somebody in their family gets sick, and then they have a come to Jesus realization. So this lack of, and Lisa was talking about state legislatures, some of this antediluvian thinking, like the anti-vaxxers, pervades the state legislatures too. So this is a countervailing force to any effort to try and improve the legislation, because it assumes that everybody's on the same page, that treatment's good. We just have to decide to who and when we can give it.
That's an excellent point.
Yes. So Lisa, with this being grading the states, if a state has an A, what comes next? Can they rest assured they have a perfect mental health system?
Well, I will say this, that it's a great place to start, because you will have a hard time putting together a good treatment system with bad laws. But with that said, there are a lot of states that we have graded high that have, an A grade, that I would not say that is where I would want to be if I was in a position of wanting to receive involuntary care. And that, like, a lot of this has to do with both the funding of the system, the number of available treatment beds, the availability of community services, the availability of voluntary community services, which impacts the flow of the entire system and the continuum of care. But then also just, as we mentioned in the report, there's a treatment law makes the tool available for the mental health system to do certain things, but there's no mandate there. So definitely you can absolutely have an excellent law on the books that is never used. And that happens in a lot of states. So what I would say the next step is, if you have an excellent law and you are still having bad outcomes, or if you have recently enacted a law that is highly graded, your next step has to be really pushing for robust implementation of the laws to the extent that you can, and setting up actual programs, and then really doing a good job of educating the people who are responsible for carrying out those laws. Which is an important point that I make a number of times throughout the report, is that, you know, the first people who are going to make a decision based on criteria are not probably going to be doctors or lawyers. They're probably going to be law enforcement, social workers, emergency room physicians who are not necessarily trained in psychiatry. So a big part of it has to be training and education for anyone who's going to be called upon to interpret whether or not someone appears to meet those criteria. So that's what I would say the next step is for a state that's got an A grade.
Okay. So it's a matter of the grade and implementation. And I think that's a great opportunity for Teresa to tell us just some of the hurdles you faced for getting access to treatment for your son, and how the grade for California reflected that experience.
So the hurdles that our family and my beloved son have faced have been horrific. And I might add my brother. I also have an older brother. So I have a 45-year history with California. And I would say that actually the D- grade is maybe a little too high based on those hurdles. But you know, I think there probably are some families that might agree with me. I mean, there were insurance hurdles, there were care coordination cliffs, there were so many hoops to jump through that put my whole family at risk. And, you know, our safety and our sanity were at risk. So, you know, I strongly believe that, you know, California can do better, must do better, and that we've been tinkering around the fray for far too long. And, you know, we have to take this report and use it as an opportunity to improve. And, you know, I know there will be some folks out there, as Dr. Lieberman was saying, you know, there's a lot of anti-psychiatry folks out there, a lot of people that, you know, involuntary care must never happen under any circumstances. And, you know, I respectfully, you know, challenge anybody to tell me that it's, you know, civil or right to provide care in a solitary cell. So, so sadly, my son did have an early diagnosis, and we wrapped him in love and support. And we were all in, you know, we had an amazing pediatrician, and we had an amazing psychiatrist. He had a diagnosis. He had a job. He graduated from high school. But on his 18th birthday, you know, he was literally hospitalized on his 18th birthday, his second 5150 involuntary hold. And I found out that day that I had no rights to, you know, help him unless he let me. And, you know, I would call the hospital and they would say, you know, sorry, can't tell you if he's here, even though I knew he was there. But yet I would get the phone call to come and pick him up. You know, can he come home? And ironically, it was, you know, after like you know, he fell into the dark hole of the adult system at that point. And it was ironically after, you know, a psychiatrist actually said, you know, you'd be really lucky if you got your son into the criminal justice system. And he said it to me as like, you know, it was like getting into Stanford or Cal. And I was so mad, talk about angry mom. And I was like, that will never happen to my son. But what I know now is that he was basically saying, that's where we're providing long-term care. That's where we're in the state of California. That's where our system of care is. And that was just crazy. And so, you know, I really believe that if we're going to unclog our prisons, our streets, our morgues, that California has to lower the bar for grave disability and raise it higher for incarceration. And we need a way to hospitalize those that need it, and the community pathways to support assisted outpatient treatment for people who do not need hospital-based care. So fortunately, after years and years of suffering, unbelievable suffering. And that was with, you know, me as a full-time advocate and mom, and we had resources and the pain, we had a lot of privilege, and that privilege did not exclude us from pain. So.
Sabah, can I just comment on Teresa's statement?
Oh, yes, please.
So, I mean, you know, I feel your pain, but doctors, because they deal with, whether it's, you know, cardiology or cancer, whether they get inured. I never get inured to hearing these stories, because in many things in illness, there's just nothing available until there's a breakthrough scientifically. But in the case of what Teresa's describing and what we're here discussing today, we don't need a new breakthrough. We don't need to find the treatment for Alzheimer's disease. We have the capacity. It's just we're not using it. And we're trying to fight the battle with our both hands tied behind our back, and it's so self-defeating. So the way I would sort of frame it is that, you know, the Treatment Advocacy Council has fought the good fight heroically for years, and in this case, has found the point of leverage legislation, and that would be a huge victory if that could be introduced and implemented effectively. But it's really addressing the tip of the iceberg. And when people get to that point, and what we really want to do, can't solve the problem of mental health care in one fell swoop overnight, because this has been in the works for centuries. But it's really working backwards, because if Teresa was able to have a ability to provide treatment even over objection, where would she get it? The infrastructure in the workforce doesn't exist. And even if there were, you know, bodies that were in places, the quality is not necessarily the optimal standard of care. So there's a big fix that's required here, but at the same time, you have to start somewhere. And this is, you know, a good place, because this is the most sort of acute and extreme end of the failed mental health care policy in the country.
Yeah, and I think Dr. Lieberman's point really brings us back to, I think, where Lisa started, which is the really important takeaway for everybody listening in today. This is not a report on the quality of the mental health system in every state. It's just not. This is about the laws and whether they provide the baseline for having a good quality system, because we feel strongly that the laws are the place where you start to build a great system. It is a necessary but not sufficient condition to having a good mental health system. So I hope people will take this report for what it is and not over extrapolate from the grades.
Absolutely.
Yeah, I mean, my state, New York, didn't fare too well on the legislation, which I know all too well, when we have to go through this bureaucratic maze to get civil commitment, or, you know, get somebody on ACT or AOT. But at the same time, New York State has a great commissioner, great staff. They're doing some very innovative things. Mike Hogan had been our current commissioner's predecessor. But it's trying to, you know, do the work with, you know, a minimal amount of the resources necessary to address the population need.
And I would, you know, I'd hop in and say that, you know, this is actually one of the things that I really want people to use this report for, is to try to identify, you know, why do certain things not seem to work? If we, you know, say, if we have this really great law for outpatient treatment, why are we still having all of these bad outcomes? And if you look at the grade sheet for New York, you can see why that is. And it's because you can't get into the system on the front end, so you never make it to the back end. And that's one of the things that I really encourage people to you know, look at the whole system and see if it's broken anywhere. Anytime that we've marked off points on the grade sheet, that's a place where people can fall out of the system. And, you know, in Teresa's case, you know, one of the big criticisms that we have for California is that it's really hard to get into that system because families don't have access to it. You cannot initiate the process as a family member, even though you're the one who's in the position to know when somebody's really doing poorly. But in California, the people who can initiate that system are medical professionals and law enforcement. And it really wasn't until Lora's Law was passed that there was even any opportunity for family members to even make a referral. And you see that when you look at the grade sheets that, you know, you can kind of start to see, oh, okay, so the problem is that we're not able to get into the system, or the problem is that our criteria are just too high and people aren't making it in.
And to Lisa's point on this recommended legislation that the Colorado Mental Health Foundation is sponsoring a forum on drafting, the recommendation is that any person could file a petition for an individual, and a single clinical certificate from a qualified mental health professional should be sufficient, instead of when I was in training, we had to get two physicians to certify an individual. So this is what you're saying, Lisa, can't get in the front door.
Yes. Speaking of the getting into the front door, and I want to go back to what Teresa said, because it relates to just everything that we're doing with your son getting into the criminal justice system. Unfortunately, that was my brother's introduction, and it could be for a number of reasons: community, race, socioeconomic background, but that's where his diagnosis was done during competency restoration. And we have a question from an attendee, and I do want to spend a little time on just the incarceration factor of severe mental illness. But the question is, how do we see the AOT commitment standards as potentially conversing with the movement to decarceration, decriminalization? And have we seen any implementation of these laws where individuals moved from one system to another? I will start by saying a state that I advocate with, Colorado, has drafted legislation that does just this. If someone is found incompetent to stand trial, they are moved from the criminal justice system to the civil system. I think it is exactly where we need to be going if we're going to take little steps in that direction. And I would love to see we have to stay niche and narrow. I do envision a day where we just embrace the criminal justice side with big open arms and create policy recommendations. But until now, we have our powerful legislation, AOT, that could help with decriminalization. And Brian or Lisa, go ahead and tell us.
I'll take it. Yeah, thank you. And it is a great question. So one thing I think is important for everybody to understand is that, as the questioner seems to recognize, AOT is civil commitment, right? It's not at its root about people who are currently in the criminal justice system. It's very different from the concept that it's often confused with mental health court, where you have people who have pending criminal charges, and it's understood that they need treatment more than they need punishment. And so a plan is devised to get them into the community, receiving treatment, and hopefully having those charges dismissed. That's not what AOT is fundamentally. And if we're AOT, you don't have to have committed a crime as the price of admission into the program. It is civil commitment. It is based on meeting civil standards. You're not in any kind of trouble when you are receiving AOT. All that said, in answer to the questioner, yes, we think there is an enormous opportunity to bring people who can't really be helped in mental health court, often because for mental health court to work, the charges have to be viable, right? You have to have a potential prosecution that's being set aside for this other opportunity. But there are many people stuck in this competency restoration limbo who are never going to get to that point, and so they can't really be helped in mental health court. Their charges can't go forward because they are not competent to stand trial. And what often happens in those cases is people are committed for a period of attempted competency restoration, even though everyone working in the system understands it's very unlikely they're going to be restored to competency within the statutory time limit. And so when that time limit hits, the charges are then dismissed, and the person is back into the community with no kind of support that's going to make it possible for them to do better or for us to expect any better outcome. That is a population for whom AOT is an obvious answer crying out for application. And the idea is if we could when we recognize this situation where a person is unlikely to be restored to competency in time, how about if we dismiss the charges up front, since we know we're probably going to have to do that eventually anyway? It's dismissal, as we say in the law, without prejudice. So theoretically, the charges could be brought back at some point. It's not as if the person is getting off completely scot-free. But we can get that person into an AOT program, have them, instead of wasting time with a futile competency restoration, get them services now, get them engaged with treatment in the community, and create an opportunity for them to do better. So there are now some state laws that facilitate that kind of transfer of cases. Florida and Nevada come to mind, and we are working actively to make that more of a common practice.
And I would hop in and say, you know, that a part of the reason why I would like to see more of this kind of investigation among states to do this kind of thing is that it's if you were to, you know, create a robust system that allows people to move from criminal charges, having them dismissed and put into AOT, what you're doing is you're acknowledging that that's a person who shouldn't have been in the criminal justice system. It represents a failure of the system that the person ended up facing charges. Especially for a lot of the crimes that are typically, you know, charged in this kind of situation being nuisance crimes or being crimes of theft or crimes that are related to homelessness or anything that definitely could have been handled as a health matter that ended up being a criminal justice matter. So, I mean, mental health court is very valuable, and I definitely would never say that it's not worth pursuing. But to me, the appropriate solution is the one that acknowledges that this is a civil matter that should not have been handled and should not be handled in the criminal justice system.
Yes, well, I was a public defender in Henry County, Georgia. I would have to say on a regular trial calendar, out of 60 cases, 5 or 6 from varying severity had some sort of mental health element, and mental health court was there. But as an attorney, I always thought, if the mens rea is not there, why are we keeping them in the system? It was great that they had that opportunity, but they should have had something else that they could transfer to. And I do, with that, Teresa, you often talk about seeing your son in handcuffs. I still personally carry the shame of being relieved, because jail meant my brother was safe, at least would eat, and we knew where he was. And it's still devastating to think jail was the silver lining in the situation. Can you please just bring us some awareness and maybe survival tips? You said your anger did go decrease some and you became an advocate, but just giving us awareness of what that space is like, and then the survival tips that you do use just so you're okay every day, even though you know it's your reality.
So sadly, sadly, we had to go through that, as I said, 40 times. And we had to, wait, we had to wait for that deterioration to take place. And I don't think anybody understands how hard it is to get a 5150. And, basically, I had to watch my son, as I've said, walk out our front door in handcuffs. And, that's the same door I carried him through as a baby. And it's not what a mom dreams of when your beautiful newborn baby comes through. And so, while we're here, we're watching, we're trying everything in our power to prevent dialing 911. We're asking for help. We are, getting support. We are, begging, our child, our loved one to, engage voluntarily. And, but then when it gets to that point, I mean, I've literally had to crawl into a back bedroom and, while my husband and daughter wait and, dial 911 and say, whisper, please hurry. And so I don't think that there's any way to possibly describe the level of suffering and how frightening it is to experience that. And then to maybe have to have law enforcement come and say, yeah, no, not ready, and, it's just the most traumatic. That only happened once, and, to me, actually. So, but that meant we were on edge. We were on edge and just waiting. And that's cruel. That's unusually cruel. And we allow unusual cruelty to take place against families like mine.
Can I comment again?
Absolutely.
Teresa somehow pushes my buttons, you know, those kinds of things happen repeatedly, and it makes me think that, you know, in medicine we talk about unmet clinical needs and healthcare disparities. You know, this is really it seems to me it's a social justice issue. It's almost a civil rights issue, and you have a whole segment of the population which has been disenfranchised because of the lack of knowledge or the ignorance or lack of valuation of a segment of the population based on, you know, a group of medical conditions. So I guess to the legal eagles, Sabah and Brian, Lisa, why isn't there a class action suit? Is there some technical reason?
Well, I mean, there have been a number of class action lawsuits. I mean, but I will say that for that to work, you have to find a very narrow issue that you have a really strong case for. And because of the fact that you have different states in every state has its own system of law. So you can only, to a certain extent, replicate what you've done in one state and another. It definitely is. I mean, like, I think a great example is in Washington State, they just settled a class action lawsuit on competency restoration that did lead to an enormous overhaul of their system. Basically, there's going to be requirements that there's only a certain number of days that can pass where a person is in jail waiting to be moved for competency restoration. But it's narrow issues like that are actually possible to handle in a class action kind of a setting. And then another issue that is to be considered is that, you know, the organizations that I know of who have done class action lawsuits are very unlikely to pursue involuntary treatment. You know, if you're talking about the ACLU, you're talking about disability rights, who do a lot of this kind of class action litigation, they are not going to be pushing for involuntary treatment. That's just not where they come down on it.
I have a question that is probably one of the more important questions that we've gotten. Brian, what is AOT? Can you explain?
Thank you. I apologize for assuming that that everyone knows what I'm talking about. We're just trying to get through so much today. But AOT, assisted outpatient treatment, is a form of civil commitment. It is about civil commitment to outpatient care. So we normally think of civil commitment about being what you do when a person is in an acute psychiatric crisis and doesn't understand their need to go to a hospital. And we as a society are saying, because you meet certain criteria, we are going to place you in that hospital for the care you need. AOT, or outpatient commitment, or assisted outpatient treatment, comes into play at a later stage in a person's treatment, right? When the person has been stabilized through hospital care and is now ready to be released back into the community, but has a history of winding up in the hospital repeatedly, or someone who's stuck in this revolving door because they have great difficulty engaging with treatment while they're in the community, often due to a lack of insight about their illness, or what's clinically known as anosognosia, a whole nother discussion we could have. When we identify those folks who are caught in this revolving door, we have an opportunity under the laws of all but 3 states to say, we would now like to civilly commit you to a program of outpatient care. So this is a mutual commitment. This is about saying to a person, we have an expectation of you that you are going to follow this certain treatment plan, but it's also just as importantly about putting the system on the hook, because a treatment plan must be presented to and approved by the court in most states. And now we have this specific set of services the person needs incorporated into the order of the court, such that the system is now on the hook to actually deliver these services. And what we hope to accomplish is, through what we call the black robe effect, the active interest in a judge and the monitoring of the court in this person's care, that both sides have additional motivation to actually remain engaged with each other. And for most people, we keep this in place for a period of time to allow the person to develop these habits of treatment compliance, so that even if they don't reach a point where many people's baseline is such that they're never going to recognize, hey, I actually have an illness, but they may very well come to recognize their lives are a whole lot better now that they are engaged with treatment. So most people are able, after a year or so, to graduate from that assisted outpatient treatment situation.
That is AOT. We will continue to do that in our advocacy efforts all the time. We have maybe time for one more wrap-up question. We have just a few minutes left. I would like to, Brian, TRAC did a 2015 study that said compared to the general population, people with mental illnesses are 16 more times likely to be killed by a police officer. What is TRAC's response to the defund the police movement and police involvement as first responders to a mental health crisis?
Sure, Sabah. Well, you know, I think the slogan defund the police is exceedingly unhelpful and a misleading way to frame the response we need to the problem of criminalization of mental illness. You know, that particular rallying cry suggests that we need to give the police less money to do police work. And whether that should actually happen is a debate that can take place elsewhere. But when it comes to responding to untreated mental illness in our communities, there's nothing to defund in policing budgets because police have never been funded to deal with that seriously. The problem has been dropped in their lap as an unfunded de facto, if not explicit, mandate. So absolutely, it is well past time to get serious about funding all kinds of things, right? A full continuum of treatment options, including inpatient psychiatric beds, non-law enforcement responses to mental health crises, such as mobile crisis outreach teams. There's this enormous need to collect data on the prevalence and the circumstances and the outcomes of police encounters with individuals with severe mental illness. And if we do all that and minimize the involvement of police in this fundamental public health problem, there will be no constituency happier about that than the law enforcement community. So, you know, that I think is where it's at. There is a need for great additional funding to address these issues holistically, but it's certainly not about, you know, a need to take on the police.
Absolutely.
I would definitely second that, you know, I mean, I've had occasion to talk to law enforcement in a lot of different settings, and there is nobody that is less thrilled about being first responders to these calls than they are. And the fact that you get unfortunate outcomes by sending people who are unqualified to deal with mental health conditions out to respond to them, you know, like that should not surprise anyone. And it isn't the fault of people who don't have the option of saying no. I mean, you know, when you call 911, somebody has to respond. And we have set up a situation where we don't respond with the right people and we don't respond with the right services, and we haven't funded that enough. And that, I think, is the real emphasis that we need to have in trying to decriminalize responses and really focus on mental health as a health situation.
Yes, it would do a lot, especially from the standpoint of the article that was shared with Washington Post. It's not so much that we are angry with the police. We asked for this on the front end, like we said. That's where we want the help to occur before we have to sneak into a closet and make that call on the people we loved. And that's what this is. The report is about, getting those tools out there, getting our message out there, firmly letting everyone know that AOT is outpatient treatment, that we want our loved ones to be healthy enough to make a choice in the continuum of care, but we have to be honest that they start off in a crisis that they never have to be in the first place. And I want to thank all of you for joining us today. This has been an excellent experience. I hope everyone walked away with answers to their questions, and we can certainly address some of the ones that we didn't get to in the chats, especially if we know your state. That's what we do. Email us and we will let you know every way that we can be helpful and give you all the information that you need. Thank you.
Have an email address up for that, Sabah? Should we just ask people?
We just did it to the, we just posted it for the attendees, so they can view the full findings of the report on our website, and you can find out how to contact us there. So Thank you so much.
It was a privilege joining you all.
Thanks.
Thank you.
So thanks so much for joining us, both Teresa and Dr. Lieberman. Really appreciate it.
Thanks, guys.
Thanks, everyone.
Thank you.
Stay safe.